Okay, good morning. It looks like we're live. We're going to give it another minute, though, for people to work through technical difficulties as they try to sign on to this webinar. So I'm going to go mute here for just about 60 seconds. For those of you still signing on, we're just giving it a minute before we kickstart this. Okay, well, it's 10:01 now, so I think we'll get things going. Everybody's got a busy day, I'm sure. Good morning, everyone, and welcome. We're at the top of the hour, so we are going to get started. Colony West is pleased to bring you today's webinar hosted by Outlook HR, featuring the illustrious Robert Huddock of Huddock Employment Law Group. And before I introduce our speakers and tell you a little bit more about Colony West, here are a few housekeeping items. Today's webinar is being recorded, and a copy of the recording will be forwarded to everyone who registered for the event, along with a copy of the presentation. Be on the lookout for that in the next day or two. If you have any questions throughout the session, please use the Q&A chat box. We do our best to address all the questions during and at the end of the presentation. Usually there's questions that we just can't get to, and I don't know Evelyn and Robert's schedule, so they may be able to make themselves available after the session ends to finish up those questions. If not, then we'll try to get to them next time. Or you can reach out to them individually. At the end of the webinar, we're going to ask you to participate in a 4-question survey. Your feedback is very helpful to us. This is our 6th or 7th webinar, and we really do use all the input and feedback that you provide us to curate future webinars, address technical issues, things like that. So we really appreciate if you can answer those 4 questions when you get the survey. In addition, Evelyn's going to show you what we haven't done before, and we're doing this time is we've put together some discounted services offered for free, or again discounted by Outlook HR to all the attendees. So please make sure to review those, and if you have any questions about any of those or would like to pursue any of those, then Evelyn, you can reach out to her directly. Thank you for pulling that up, Evelyn. Now for the main event. For those of you who are new to Colony West, we are a full-service advisor providing solutions for insurance, payroll, HR, and safety. We take a unique approach to every business and specifically address your individual needs and risks. We are pleased to be able to bring our clients and others valuable, insightful information around risk management, labor, and safety compliance. As I mentioned, Outlook HR is hosting today's webinar. The team at Outlook HR has partnered with Colony West in providing customized, innovative solutions to workforce management, including payroll, HR, and safety. I am pleased to present Evelyn Blanco of Outlook HR. Evelyn has over 20 years experience in human resource management and is certified by SHRM. She is bilingual in Spanish, and because of her extensive experience, she is able to guide and support her clients with practical implementation and reasonable implementation while keeping all areas of compliance in place. She has seen and heard just about everything, and I think she's working on her first novel of HR anecdotes, as well as our esteemed panelist, Robert Huddock. Robert has over a 20-year law career, with 15 of those specifically representing employers in employment law matters. I know Robert's helped out many of our clients in some tricky situations. Robert has also provides employers with employment law education and solutions to protect themselves from claims and navigate difficult workplace challenges. Now I'm going to hand it off to Evelyn of Outlook HR, and Evelyn, take it away, please.
Good morning, everybody. Thanks so much for taking the time to join us. So we're going to go ahead and jump in and get this started. we know you're very busy, and we do appreciate your participation. So of course, we're going to talk about the upcoming laws that are going to be effective in 2022. The agenda is as follows. We're going to go over the laws that are effective in 22. We're going to go over, and I'm not going to go over them individually as we're going to speak to them. We're also going to talk about all COVID related updates, and then some case law that was decided in 2021. So let's go ahead and jump right in. Okay, Robert, personnel records retention, record requirements, which is SB 807. And we also have no legal definition of what is personnel or employment records. So throughout my career, I know it's changed from 7 years to, and some people think it's 3 years that you have to keep personnel records. And now it's something different. And what does a personnel record even, what constitutes a personnel record? Can you help us out with this one?
Yeah, of course. Well, I can help you out as much as California law will allow me to, which a lot of times isn't definitive, but we can do our best. Mm-hmm. As you mentioned, there is no legal definition of a personnel file, and that's maybe a misconception among folks. You will see, perhaps, for example, on the DLSE website, a statement of what a personnel record is in their opinion, but there is no legal definition of a personnel record, so you use your best judgment. I think that's pretty well defined by employers internally, and I think that anything reasonable in the scope of what you have will suffice. Now, in terms of the time for maintaining those records, you mentioned, there's one in particular you mentioned that I want to comment on, and that's this one about 7 years, because I've heard that referenced, thrown around as well. And there's never been a 7-year standard. It's just something that's spread around the industry, and what it refers to, at least in my experience, is, well, I guess it's the same thing, because what I've heard it say is you have to keep them for 7 years before you can destroy them. Right. There is not any standard to that effect. Let's talk about what the standard actually is now with the new law. And so the new law extends the period during which an employer is required to maintain personal records to 4 years. What it says in the statute is not just personnel records, but it says that employers must maintain all applications, personnel, membership, or employment referral records and files for 4 years. The statute also states two measurements of the 4 years. One is 4 years after the records and files are initially created or received, and then for applicants and terminated employees, 4 years after the date of the employment action taken. Now, this is confusing because every employee, or not everyone, but a lot of employees eventually become a terminated employee. So right. if you use the standard of 4 years after they were created, first, what is initially created or received, and also if you use that 4 year standard, and then that employee is terminated 6 years after, that creates some confusion. And I'm going to talk a little bit about what's best to do, what's the safest thing to do, after I tell you about a different standard that applies in different circumstances. And what the statute says is there's a rule when you have what's called a verified complaint. The statute specifically says verified. And a verified complaint is something very specific. And just very briefly, it means that there is a specific attestation by the party bringing the complaint that everything is true and correct. And that's actually a very rare thing, that you have a verified complaint. But the standard with respect to verified complaints is that an employer must maintain records and files until the later of the following two. and that's the first date after the period of time for filing a civil action has expired. In other words, after the expiration of the statute of limitations, or the first date after the complaint has been fully and finally resolved. So what's the safest thing to do with all these different standards? What I believe in that regard and what I would recommend is, and don't forget, it's also talking about applicants. So you need to be cognizant of that, maintaining those records with respect to applications or applicants. And so for applicants that are not offered employment, my recommendation is to keep all application materials for 4 years after they've been submitted or thereabouts,
Okay.
or after a decision on the application, whichever is more applicable in your particular circumstance. For employees, and that's whether it's current or former, you anticipate them being former employees at some point, and the safest thing to do is maintain all the records throughout the employment, not just 4 years, and also retain the records for 4 years after termination. That's going to cover all your bases.
Okay.
And now with electronic storage, it's not something necessarily that's going to be an administrative or practical burden necessarily.
Right.
And then for employees who file claims, essentially, so what attorneys will refer to and what exists in the law is something called a litigation hold. So an employee files a claim, you put on a litigation hold, meaning everything you have regarding that employee, doesn't get touched, and it stays that way until resolution of the lawsuit or the claim. And so for those employees, again, the safest thing to do is to keep them until the statute of limitations for filing a complaint, because sometimes there's a claim before there's a complaint, but keep them until the statute of limitations for filing a complaint expires, or that situation where the claim is fully and finally resolved. And, as I mentioned, I think that the upside is actually, being safer than sorry. The downside could be some kind of administrative burden associated with keeping the files, but it also could be where you have records from that you don't necessarily legally need to keep, that you wouldn't necessarily want to produce in a lawsuit, let's say. However, unless the record, in my opinion, unless the records are really bad, the employer is the one that's always at a disadvantage when you don't have the records, because there are going to be assumptions made, whether legally or practically, that, whatever the employee says about what the case was is going to be accepted more than what the employer says, because it's just he said, she said at that point.
Right. Okay, we do have one question, and it says, after the 4 years are up, what is the appropriate way to dispose of the files if they're physical copies? Should they be shredded?
Absolutely.
Okay, great. So just to recap, the safest way, always on the conservative end, is to save for terminated employees, is to save it for 4 years after termination. Is that correct?
Well, correct. And it's basically for all employees, you're keeping it during the entire period of their employment.
Obviously, yes, right. Understood.
And so let's just say you have an employee that's still employed, you're going to continue to maintain the records for them. And then the only time that you're going to destroy is 4 years after an employee is terminated. Again, that's not necessarily required, but is there really a downside to it? And there's a high upside.
Right, absolutely. And I also wanted to mention in regards to, what is a personnel record and what should and should not go into a personnel file. In my experience working with clients, oftentimes they put, everything in that file, and they combine everything in a personnel file. And sometimes it's too much and they don't know what they should and should not separate. And so I just wanted to put out there to everybody attending that is something that Outlook HR does help our clients with. We do audit employment records and employee files so that, to help you protect yourself, were there to be an audit of any kind and were there to be litigation of any kind, we're here to help. And that's something we definitely assist our clients with. And please reach out if you have any questions. We can do assessments to help you with that. And it looks like we have another question. Okay, it says, if we receive resumes and perform interviews based on those resumes, but do not get applications until we are actually ready to move forward, do we still need to save records on those we have interviewed?
Yes, because the application materials that they're referring to are not just things that are called applications, but it's anything that a prospective employee submits in connection with potentially getting employed. Right,
is it safe to say that an interview constitutes the same thing because you have now actually considered that applicant? You don't need an actual application to consider them.
Agreed.
Okay. All right. So the next one. Oops. Okay. Terms and settlement agreements, severance agreements, and restrictive agreements during employment. So there's a lot of words of agreements here. So I'll let you talk about this. And then at the end of it, I want you to tell us what is the takeaway for employers on this?
Of course, of course. And so this isn't necessarily a practical, except for one, a practical thing that employers necessarily need to pay attention to, because when it comes time, at least to do a settlement agreement, you're going to have an attorney handling that and making sure that everything is essentially in order. And I believe you should do the same for any severance agreement. But I think it's important. I think it's going to be something of interest to you because it does. Any employer who's been involved in the claim, in my experience, has had concerns about what we're about to talk about. And so the statute separates, there are terms that are applicable to settlement agreements, which means the resolution of a claim, versus severance agreements, which is an agreement that's given in exchange at the termination of someone's employment for it's an agreement that's obtained that has a release for future claims. And that's in exchange for something that you give the employee that is beyond what you already owe them. So let's talk about this. For purposes of settlement agreements, it's really just an expansion of what had already existed. And let me explain. I think it was 2019 where the statute first, or the legislature first enacted a statute that dealt with this. At that time, it was restricting non-disclosure agreements, meaning you can't talk to anybody. It's almost the same as a confidentiality agreement, but a little bit different. We won't get into the nuances here. But what the legislature did at that time was limit non-disclosure agreements, saying you can't have a settlement agreement preclude an employee from sharing information about sexual harassment or discrimination or retaliation. Now, with this newly effective statute, it's extending it into any forms of harassment, discrimination, or retaliation. And that's going to be all your protected categories, which is age, disability, and sex and gender, and so forth. So that's the change there. What's interesting about this, because I do believe that employers are most concerned about confidentiality agreements, and basically what we're talking about here is a term in the settlement agreement that says essentially, by agreeing to this settlement in exchange for the money that we're giving you in settlement, you're agreeing not to talk with anyone about the settlement. And let's talk about that a little bit. And there's differences of opinion as to what the scope is of what can be limited about an employee, disclosing about the settlement. Is it the amount of settlement? Is it the fact of the settlement? And things like that. On that issue, what the new statute says is that settlement agreements, it specifically authorizes or says that this does not preclude provisions that preclude disclosure of quote unquote amount paid in settlement of a claim. So if you were to read that completely literally and only that, it would basically be a confidentiality agreement saying, well, they paid me $50,000 to settle this claim. I do think it's broader than that. And I think it's still the same. The scope of what the confidentiality agreement is still the same as before this statute goes into effect. And that is basically saying the most you can say is the matter has been resolved, essentially.
Okay.
And I would continue to do that in settlement agreements with my clients. And what you can do is you can put what's called a carve out or an exception to any confidentiality agreement saying this does not preclude you from, disclosing information about, and then just use the statute. And that's what I've already been doing with respect to settlement agreements when it deals with sexual harassment, discrimination, and retaliation. That's the way you protect yourself in that situation.
We do have a question.
Yes.
It says, is there a punishment for including that language, or is it just considered unenforceable?
Good question. And it is just, there is no penalty or anything like that. It would be that, well, actually, let me revise that. I do think that there is associated some kind of penalty and attorney fee revision. I cannot say for certain as I sit here right now, but it would definitely be considered unenforceable. And the danger there with unenforceability is that sometimes it's not just the offending term that is ruled unenforceable in this situation. Sometimes it's surrounding terms. If the offending term is too intertwined with other terms, so perhaps maybe it takes out all of the confidentiality agreement. And to protect against that, you make sure that the confidentiality agreement is stated in such a way where that's completely severable. That stands alone. And that's the kind of thing that I'm talking about in terms of, the carve out and that type of thing. You protect yourself against the entire confidentiality agreement being ruled unenforceable. Now, severance agreements is going to be more of a practical consideration for employers to the extent they use settlement agreements or they do in the future. And the situation there is, and I'll use the terms in the statute, and then I can explain them. And that is the statute that will go into effect, or the terms of the statute that will go into effect, is that going forward, it precludes terms that prohibit discussion or disclosure of unlawful acts in the workplace. So here's where a distinction between severance and settlement is important. And that is, settlement, the term regarding settlement agreements does not go as broad as unlawful acts, which unlawful acts is broad, because it would include violations of the labor code and anything that could be considered unlawful. And that's pretty broad. So it's not just harassment, discrimination, and retaliation like it is in the case of settlement agreements. Now, here's the important part. And look, if I would highly recommend that if you're doing a severance agreement, it's time well spent to have an attorney either prepare that for you or review anything that you have in mind, so that the severance agreement has value and that it'll be enforceable. And so one of the terms to be cognizant of that is required with the new statute is that there is a provision. There are certain provisions that must be included. And to any of you that have experience with terms that need to be included in a resolution of an age discrimination claim, these are somewhat similar. And that is, you need to specifically include a provision that says that the employee has a right to consult. And this is something that's important practically, and I'll tell you why after I tell you about the technical terms themselves. You need to have a provision in a settlement agreement, a severance agreement, that says the employee has a right to consult an attorney, and that the employee will have no less than 5 days to do so after they've been presented with the agreement. Now, the employee may sign that agreement before the expiration of the period, as long as, and what the statute said is, the decision is knowing and intentional. The decision is not induced by fraud, misrepresentation, or the like, and or the employer does not provide different terms to employees who sign such agreement before expiration versus those that sign after expiration of that 5-day period. Here's a practical importance of that. At least in the past, there was no specific terms that required you to state, number one, to state specifically that they have, in connection with the severance agreement, that they have this right to consult with an attorney. It's still in the severance agreement, but not so directly. And the thing that's completely new is that you have to give them 5 days to consult with an attorney. And so, as a practical matter, in the past, you've had a situation where, okay, you offer a severance to an employee, and they're going to decide at that time whether they either want the payment or they want to retain their right to maintain a claim. And I'd say 8 times out of 10 on average, they're going to decide at that moment that they want the money. But if they had more time to consider it and ask a plaintiff's attorney about this, it's probably going to adjust their view, whether right or wrong, or whether in their best interest. And so, that's something that we'll see how it works, but that might be a situation where severance agreements are less likely to be executed. I don't think that changes anything as far as whether they should be offered, but that reality exists going forward.
Got it.
But there's one more thing I want to briefly talk about, because the statute also talks about what I call restrictive agreements during employment. This doesn't necessarily, in my experience, this doesn't necessarily happen much, but if any employers in attendance here have such things, it's important to know this. And that is what the changes or the new statute terms say is that the employer cannot require an employee, in exchange for a raise or a bonus, or as a condition of employment or continued employment, something that says the employee is agreeing that they're giving up rights, or that affects their otherwise legal rights to disclose information. And that would be something like, that you hand out at the beginning of employment, where it says, I agree that, I don't have these certain, a right to an overtime claim, or, a right to a harassment claim, or that type of thing, which is because during employment is different than a severance agreement at the end of employment. Those are allowed. It's not allowed during during employment. And that's the most succinct way to say it. So one of the things that we're going to talk about a little bit later is what you can do during employment to protect yourself with respect to potential wage and hour claims. But we will get to that later.
We have one more question. It says, what about for regular paychecks?
What about, I would need a little bit more.
I think he's talking about as to whether an employer can require an exchange for a raise, or for, can they execute a statement that the individual does not possess any claim or injury against the employer?
Yes, and that is exactly what I'm talking about when I say we're going to talk about ways you can protect yourself with respect to wage and hour claims. And just to introduce that topic for now, what I'm talking about is, and this is in use now, and this is something that I recommend to my employers, and it's allowed, and it will still be allowed after this change, and that is what I'll call an attestation to certain things that when you're getting your paycheck. And that is things like, I agree that I've taken my meal periods, or if there's a missed punch or something like that, that's the reason it happened was because X, Y, Z. We can talk more about the details of that later, but and you can have them execute that every pay period. And I recommend that. However, you can never make it a condition of receiving their pay. And you put a term of that into the attestation. We can talk about details of that a little bit later when we talk about the some of the laws that are more specific to that.
Okay, so because this person elaborated and says, can an employer have the employee confirm whether or not they had any workplace incidents since the last payday? Which I think you just answered that already.
Yeah, so here's the distinction. Factual attestations are one thing. Legal attestations are another. To demonstrate the distinction, saying I have no right to overtime isn't allowed.
Right.
And I waive any overtime claims and that sort of thing isn't allowed. But to say, I have been paid for all overtime hours I worked is factual.
Right. Okay. And then we have another one that says, does this affect seeking releases in response to a class action, i.e. Chandara versus pickup sticks?
Well, pickup sticks talks about settling with class action members before class certification, which is allowed, which is a different subject. So I'm not sure I'm answering the best way I can, given my limited understanding of the question. But, and I think I know what it means as I'm thinking about it. And I think what it means is having them sign this attestation that we're talking about, a settlement that is considered, a settlement with a class action member that eliminates them from the class. And the answer is no, because that would be what the pickup sticks would be, a payment of something that you don't already owe them, number one. And number two, it would be considered a release, which is not allowed in an attestation. What you're doing in an attestation is doing what an employer can best do to establish the underlying facts that would establish that there is no legal right or there was no violation.
Yeah, he just elaborated and said, I just want to ensure there's no limitations on getting releases while employed.
There is. The difference is, a release during employment versus a release at the end of employment or when a claim has been resolved. Essentially, and there is no release in an attestation. Again, attestation about the facts, and you're trying to, give yourself an argument as to what happened as to the facts, with meal period punches and things like that. So I hope that answers the question.
I hope so as well. Okay, let's move on. Let's see. Okay, wage theft is criminal grand theft. So if I am reading this correctly, this is just making it harder for employers to do business in California. Am I right?
Yeah, so I don't want to be a fear mongerer here, but and I'll explain why it's not necessarily something that is momentous and you should be particularly concerned about as a practical matter. So wage theft, a lot of you may have been have heard that term before, and really it's a term that's been coined by the plaintiffs bar and employee advocate groups to make things sound a little bit worse. And really all it refers to is not paying what you otherwise owe. That's the wage theft. Now, the labor code has for a long time had within it or associated with it criminal penalties, such as it's a misdemeanor to whatever, a violation of whatever labor code that the statute that has that misdemeanor penalty refers to. The change is that now the legislature is putting a criminal penalty within the penal code and making it grand theft, which, well, it could be grand theft when it's over a certain amount, for which a higher criminal penalty could attach. Now, as a practical matter, even before this, it is extremely rare for there being any actual prosecution of or seeking even of criminal penalties. In my humble opinion, I think the real purpose of these attaching of criminal penalties is not necessarily to get them, but to serve as settlement leverage for employment-related claims. And I think that this one's no different.
So it's fair to say that generally speaking, these aren't really enforced.
They're just not enforced, at least historically. There's always the chance that they could, but it's been so rare. I don't know of one specific case in which it has. That's not to say that it hasn't, but they're that rare that I haven't heard of it. And okay. It would only be in the most egregious situation, which I'm sure anyone in attendance, just by virtue of the fact that they're attending, isn't someone that would have such an egregious situation.
Right, right. And then we have a question. It says, is this statute retroactive?
No, the criminal penalties? No.
Yeah. No. Okay. Okay. Moving along. So expansion of qualifying family members for FMLA and CFRA leave to include parents-in-law. So this seems simple enough to me. It's adding parents-in-law. So I have a mother-in-law or a father-in-law. I can now take FMLA or CFRA to take care of either one of them. Not my sister-in-law, not my cousin-in-law, but either one of either my mother-in-law or my father-in-law, correct?
All correct. And strictly speaking, this is a relatively minor expansion of the law, but here's where it's important, I suppose, and that is, and some of you may not even be aware of this, and that is, it's no longer a situation because of a statute that went into effect in January 2020. It's no longer the situation where you have to have 50 or more employees in a 75-mile radius in order for CAFRA leave, anyway, the state law regarding leave, to apply. That law brought it all the way down to 5. And so all of you with 5 to 50 employees, technically during 2020, that was required, and it's remaining this going forward. So all of you with 5 to 50 need to be paying attention to this very closely, and you need to become at least generally familiar with the family and medical leave laws. Now, there's medical leave and there's family leave. Family leave talks about time off to care for a family member. The definition of family member has always included parents, but now the expansion is to parents-in-law.
Right.
And there you have it.
Great. That was simple enough. Yay for a simple one. Okay, now we're going to talk about limited additions to exceptions from AB 5. So AB 5 already had some exceptions, and now there have been some additions to that list of exceptions, correct?
Yes, and this is another even more minor change to an existing law. So you've had since the beginning various employees in various industries that have not been subject to AB 5. And now let's keep in mind, when we talk about an exception to AB 5, that doesn't mean that there's no standard that an employer needs to prove that the worker is an independent contractor It
Right.
just means that those industries that are accepted are subject to a different test, albeit a test that is easier to establish independent contractor status.
Which I wanted to elaborate, because I know that oftentimes employers put people in that category without realizing that there is a process to classifying somebody correctly as an independent contractor. It's not simply, I want to put you as an independent contractor, and that there are some serious ramifications in misclassifying somebody as an independent contractor, which can be enormous. And this is something also that Outlook HR can assist you with, and that we can help you make sure that you're in compliance in properly classifying a worker as an independent contractor. And oftentimes people use the word, oh, that's a 1099 employee. Well, you never use the word employee when referring to an independent contractor. And that's a misnomer as well. So go ahead. I just wanted to make sure that.
No, and I agree with all of that. And I think I'd like to address a few things in connection with what you said. And number one, with respect to the different tests, the other test is referred to in the legal circles as the Borreloa Test. And Borreloa is just the name of a case in which the test was announced. And to put it succinctly, the Borreloa Test is focused on what right of control the purported, and I call it the principal, has over the independent contractor or worker. So that is a good segue into, well, and then AB5 in contrast is much more difficult, if for no other reason than you have to prove, among other things, that the purported independent contractor is not doing a nature of work that is the employer's nature of work. And that eliminates a lot of instances in which employers have classified workers as independent contractors. Correct. In terms of nomenclature, I think that's important. I think it's important to, from the beginning, use the right nomenclature, because then you're establishing a narrative that someone will try to latch onto if there's a claim. More specifically, if an employer is seeking to establish someone as an independent contractor, you never want to use the word employee in that reference. Worker, use worker. Yes. And you don't use employer when talking about your company. You use principal, meaning the other party to the independent contract, and that type of thing. And then there is a mix up of 1099 and W-2, employee, etc. Because I've heard that too. That person's a W-2 employee, where that other person's a 1099 employee. That's wrong. W-2 is what, and really the fact of the matter is, W-2 is the tax form that is used for employees, and 1099 is the tax form that's used for independent contractors. Correct. The status is employee and independent contractor. And so really I think it would be a wise idea not to necessarily refer to the classifications by the tax form that's used for that classification. Yeah. And one more thing. You referenced, Evelyn, the type of exposure that you might have if you misclassify. And let me just address what that exposure might be. First of all, the labor code has some stiff penalties associated with misclassification. I want to say that the first offense is $10,000 and the next one is $15,000 or something around those amounts. And that's for each employee for which you do that, or each worker for which an employer does that. That's number one. More significantly and what happens is when you have a misclassification case, and that's with respect to either a misclassification on the issue of independent contractor versus employee, or a misclassification of an employee as exempt versus non-exempt. And that is, if you've treated that person as if you classified and treated this worker as an independent contractor, you necessarily haven't given that worker the rights that are required to be provided for an employee. You're talking about meal periods. You're talking about overtime. You're talking about wage statements, so on and so forth. And so if you misclassify someone as an independent contractor, all of those claims will necessarily flow from it. So be conservative with your classifications, and really the important thing to remember that essentially categorically excludes someone from being an independent contractor is if they are performing work that is part of what that employer or company does as a business. The kiss of death is when you have one worker that's classified as an independent contractor and another worker who does the same thing who's an employee. You're done. You're just done.
Yeah.
And so never do that. Now, there are some distinctions and decisions to be made and interpretation to be done when you talk about, okay, what is within the business of the employer? So for example, you may have a situation where, you put on it some kind of adult program for seniors or something like that. And there's transportation that's provided for that program. Is that transportation in the nature of what the employer does? Is that part of what they provide?
Mm-hmm.
Arguably, it could be, but you could make the argument that says, no, we are really in the business of providing these services for seniors. This is just, the transportation is just an adjunct. But I mention this only to demonstrate the kinds of situations where there might be a decision to be made on that issue of whether the work in question is within the nature of the business of that employer.
Okay, we have a question. Can a company who use maintenance workers have independent maintenance contractors who sign that they are independent contractors and have limited liability insurance?
Yeah, so I can answer that question even without any of the other material. If what they're referring to is, for example, let's say my law firm. If I have, and well, that's a bad example because we have building people that do that. But let's just say I didn't have those building people and my air conditioning broke down and I had someone come in and fix that air conditioning. That is a classic example of someone who does work that is not in the nature of the business that the potential employer is in. Classic example. And so if that's the type of thing this attendee is actually referring to, then you don't even necessarily need any of that additional stuff. What I can say is that in these situations, what the company and the worker agree to in writing is almost irrelevant. What's relevant is what actually happens, what actually is present, and how the law gets applied to that. Because you could have a situation where, okay, someone hires someone that's in the IT business, and they have a worker that provides IT services. Not necessarily. And let's be. I don't want to get too into the weeds here, so I'm going to skip that for now. Let's suffice it to say that an agreement that exists that has terms in it that suggest independent contractor relationship could always assist in an argument for a factual situation that otherwise sets up an independent contractor relationship, but it's not going to establish it by itself, and it's certainly not going to override any facts.
Got it. Okay. Here we go.
And let's just very quickly, as far as those limited additions to the exceptions to AB5, they're somewhat obscure. In a lot of cases, they're somewhat obscure industries like newspaper carriers, manicurists, data aggregators for market research. More widely applicable would be the addition of insurance claim adjusters and insurance third-party administrators. But that's the extent, that list there is the extent of the industries that were added. But of course, as we mentioned, there are a number of industries that are already, that were already made exceptions to AB5 and therefore are subject rather to the Borreloa test that is focused on control.
Got it. Okay. So now we're going to go on to industry-specific statutes.
Yes, and what I mean by, or what is meant by industry-specific statutes is that there are a number of statutes, employment-related statutes, that are going into effect for January 1, 2022, that don't apply to all employers generally. These industry-specific statutes apply only to employers in an industry that is specified in the statute. Because we want to keep the content of our presentation today to that which is most widely applicable to most attendees, I'm not going to get into those industry-specific statutes, but I did list the industries which have industry-specific statutes going into effect on January 1st, so that if any of you happen to be in one of those industries, you can consult with your HR consultant or attorney about what those industry-specific new requirements are.
Okay, so let's go over some of the hottest things that are going on in our world in the last 18 months, almost 2 years come this March, and updates in regards to COVID.
Sure, and there haven't necessarily been any recent changes to the law. And so what I wanted to do here was just provide a recap, if you will, of the employment-related laws and work-related laws that have been in effect for at least a few months, and talk about those a little bit, and then perhaps handle any questions, specific questions that might come up as a result of this discussion. So let me just get into it, and I'll demonstrate more of what I mean by what I just said. So what body of laws, let's call it, or what requirements or guidelines are most important to employers with respect to COVID going forward? So I think the most important and most talked about anyway is the vaccination mandates. And then there is also what's called, it's the Cal-OSHA, and it's called the Emergency Temporary Standards. And those emergency temporary standards include many things with respect to what an employer needs to do as far as preparing the workplace, maintaining the workplace, and communication with employers and government agencies about instances of COVID. Well, I'll talk about that a little bit more after we talk about vaccine mandates. There hasn't been any really important developments in the law in California regarding vaccine mandates since, I suppose, the September California Department of Health mandate with respect to healthcare workers. So what I want to, I guess, reiterate is, the vaccine mandates, despite what you may have heard in the news about protests and things like that, they remain, at least in California, legally permissible. And that is still confirmed by the Department of Fair Employment and Housing guidelines, which speak to this. And so what does that mean that a vaccine mandate is allowed specifically? It means that an employer can have a policy that all employees, at least in the category that I'm about to talk about, must be vaccinated, or they can't. Well, let me talk about that. When we talk about a vaccine mandate, we're talking about people or employees who have exposure to other employees or clients, because otherwise a vaccine mandate doesn't really have a basis. If they're home and working by themselves, there's not a basis for a mandate for a vaccine because they don't put anybody else at risk. However, if they're coming into the workplace, automatically they're putting all the other people there at risk. And if they're seeing your clients face to face, then certainly that puts the clients at risk, neither of which are positive things for an employer. So what it means, or what the mandate means, is that an employer can legally require those types of employees to be vaccinated or face disciplinary action up to and including termination. So there are two main exceptions to a vaccine mandate. And again, those are disability and sincerely held religious belief. Most of the talk and controversy and differences of opinion have been around the exception for sincerely held religious belief. And since the health mandate, the mandate for healthcare workers has gone into effect, there's been a lot of put into practice and requirements to actually interpret this. And one of the things that I've most frequently seen among my clients and in my experience is where an employee will submit a statement that, in one form or another, fundamentally cites, for example, scripture, or portions of the Bible, and says that, these scriptures support their agreement or their belief that, something to the effect, and some of these kind of don't make sense, but what I've seen is that somehow these scriptures support their belief that, God will protect them and they don't need a vaccine mandate, which technically isn't something that prevents them from getting a vaccine. But that's what I've seen actually most frequently in this area. And I believe, and I've advised my clients accordingly, that something along the lines of what I've just stated does not qualify as a sincerely held religious belief. Number one, even if it did qualify as a sincerely held religious belief, as I just mentioned, it's not the requirement for the exception is that it prevents them. Whatever the belief is prevents them from getting the vaccine. But more importantly, there is a definition of sincerely held religious belief within the FEHA, which I won't go into the particulars now, but whatever the employee is submitting in support of that exception has to meet those definitions. And I'll just say for now that what I've seen in these types of exception requests does not qualify for that sincerely held religious belief for purposes of the vaccine mandate. Now, also, I will mention this, as a practical matter, let's think about that. If what I just described was a valid exception, and all someone needed to do was find something on the internet and copy it and submit it, and that would qualify them for the sincerely held religious belief, the exception would swallow the rule. And so I don't think that's a reasonable interpretation as a result of that. The other thing to consider with respect to any exception is the practical implications or considerations. So, or any vaccine mandate for that matter. And that is more specifically, what effect does the employer believe that's going to have on their workforce? Is there a key employee that you believe is going to, resist the mandate? And therefore, under the policy, you'd have to, if you have a policy that says termination, you would have to let them go. Is there a large percentage of the workforce that you believe would oppose the vaccine mandate such that your business wouldn't be sustainable without that percentage? Those are the types of things that you need to consider. Also, is there a high administrative cost to having such a policy? For example, administering these exception requests. Maybe, not necessarily, but that's something to consider as a practical matter. One thing that I would recommend with respect to vaccine mandates, strongly recommend, is if you are going to do one, that you have a detailed written policy that states the vaccination policy, because a lot of times number one, you want to use that in terms of defending yourself against the vaccination policy if a claim came up, but also just having employees informed helps you when any claim comes up. And so, for example, the written vaccination policy would include things like the stating generally the legal basis, and also stating generally what the specific terms, or stating the specific terms of that vaccination policy, so it's very clear.
Robert?
Yes.
Yeah, we have a few questions, and I also wanted to add something that some of the mandates have already been put in place for certain cities. I know that West Hollywood was the first one in early October. As of today, I think Los Angeles had one for restaurants. So, and of course, there's the emergency temporary standard now as well that's coming up. So I just want to make everybody aware to make sure that wherever your business is at, make sure you're complying with your municipality or city. And now we have 4 questions to answer as well.
Actually, let me address something while I have it in my mind with respect to what you just said. Let's make sure we are distinguishing between mandates imposed by the government versus vaccination policies.
Right.
If you have a mandate that is, if you have a government entity requiring a vaccination policy, then you have to do it. But otherwise, it's an election and you can legally do it. Now, another thing to keep in mind with respect to government mandates, and let's just talk specifically to demonstrate the point about the healthcare mandate. Because there's some misconceptions about that, and there's important things to know about this with respect to, oh, well, is it they either get a vaccine or they get tested? Is that the standard? Actually, it's not, even with, at least with that healthcare mandate. And let me explain a little bit more. What the healthcare mandate says is you either get a vaccine or you meet for an exception and get tested. It's not that the employee under a vaccination mandate has a choice between vaccination and testing. That's an important distinction to make.
Yeah, definitely.
And here, an interesting one lawsuit that I'm aware of that has arisen out of this issue is a case in Tennessee. But when I tell you about the facts of it, you're going to see why that developed into a lawsuit, and it wouldn't necessarily develop into a lawsuit if you administered the mandate correctly. Because in the Tennessee lawsuit, what the employer did was for the people who qualified for an exception, the employer put those people on unpaid leave. You can't do that. If they meet for an exception, that means they can still, come into the workplace and do whatever every other employee does. Right. But they have to get tested. And so that's just a real world application or real world employer practice that was implemented that got them into trouble. And the one other thing that I want to mention on the flip side of what you said about these mandates is that some states have enacted, or they're seeking to enact, some people are seeking to enact statutes that ban vaccine mandates. That's nothing that's underway in California, and it's not going to happen, given all these mandates, these separate mandates and the California mandates that have gone into effect. And so, and because of all those mandates that have gone into effect, both in California and elsewhere, that is a strong support for the legality of these mandates. And so I guess what I could say about that is you're not necessarily at the same risk in instituting a vaccine mandate as you would with risks that you take with these wage and hour laws, because this is a widespread acceptance of the vaccine mandate. So as long as you do it correctly, then you're going to be on safe ground.
Okay.
And then the final thing, or actually that is the final thing that I wanted to mention before addressing the questions.
Okay, here we go. They're growing. They keep coming. As you were talking, they're coming. So the first one is, does the employer have to accept religious exemptions?
Yes, if they're qualifying religious exemptions, then the answer is yes. The question is it a qualifying sincerely held religious belief? And again, if someone qualifies for the sincerely held religious belief, they need to be tested according to what the testing rules are.
Okay, and then the next one is, does this include temporary workers hired through an outside agency service?
An employer would want to include anyone who comes into the workplace, with the possible exception of clients. But many employers have instituted it with the possible exception of clients. But let's say there's some kind of mandate that, people entering a business, anyone entering a business needs to show proof of vaccination.
In Los Angeles, patrons have to show proof of vaccination.
In certain
restaurants.
Yes, in certain industries. Yeah. But I guess to get back to that exact question, employers are definitely going to want to have that mandate apply to people who spend an extended period of time in the workplace. Either they show valid proof of vaccination or they're not allowed to come into the workplace.
But so in this particular instance with this question, wouldn't the employer have a right to say, well, we're not actually your employer is the agency, the temporary agency. And they could say your assignment is over here, go back to your agency. They shouldn't be in trouble, right?
Well, certainly. So as I understand the question, it's basically saying, is there a method by which an employer exclude hold on a second. Actually, I was thinking of something different. This is a temporary worker?
Yes, so it says, does this include temporary workers hired through an outside agency?
Here's the problem with that. Joint employment.
Mm-hmm.
Big deal in California and other places.
Oh,
now.
So he just elaborated on the question. He said, so it's for the 100 employee threshold for the mandate. Does it include temporary workers? I would say yes.
Well, here's the thing. Who is an employee of your company? That's the inquiry.
Right.
And so if you have people performing work for your company that you have some kind of control, and we're going to get to an issue of joint employment with the cases, but if you have a worker that's working, for your company, that you have some kind of control over, which you likely do, then that person would be considered a joint employee of whoever provided them and you. And so certainly for purposes of counting, that person is legally an employee, and therefore they would be included in the count.
Right. Okay. So can an employee file for unemployment if fired due to not receiving the vaccine? They
My
can
understanding
file.
is yes.
Okay.
And the one thing about that, just the mention of unemployment, the enhanced benefits are over.
Right.
As of, I believe, September
30th.
And so just to let employers who don't already know that know it, and hopefully that's going to at least partially address this problem where employers aren't able to get people in because they do better sitting at home financially.
Okay, so we have a hybrid workplace. When looking at local requirements, do we have to look at where our office is located and where they live when working from home? So I would say it's just their office.
Yeah, so there's always these line drawing problems when you have this patchwork of local requirements, whether it be minimum wage, sick time, whatever. But in this situation, if, as I mentioned before, the vaccine mandate can only reasonably apply to someone that's in a workplace with other people or client facing. If they're working by themselves, then the mandate doesn't reasonably apply. So if that's what the situation is here, then that's easily resolved. But if it's another situation where, for example, you have an employer has 20 employees that work in the city of Los Angeles, and another 90 that work outside the city of Los Angeles. Does that mean for an 100 employee count, do both of them considered towards the count? In that situation, I'd say no, because it would be where the employees are performing work, where the standard, or at least the count, would apply, or the standard with respect to vaccine mandates would apply. Then you get into a whole nother complication if you've got client-facing employees who work in multiple states, sales rep, whatever, and that are actually visiting clients, and that's a
bigger question.
Much. But that said, there's some material. There is a case that deals with the issue of which employment laws apply when an employee works in different states. A narrow issue within that issue, but we'll talk about it.
Okay. And then we have two more. What is considered a sincerely held religious belief? What wording are we looking for to determine if it is or not?
There are, I don't have it like in front of me, so I can't recite them to you. But there are three requirements that are stated in the regulations interpreting the Fair Employment and Housing Act. And if it helps people, employers that are and people who are in attendance, I don't know if there's a process by which something is being sent out.
Yeah, we're going to send out the recording and then the presentation.
Oh, well, I was just thinking about whether we could send attendees, the statement of these three requirements for sincerely held religious belief. It has to do with what I remember of it off the top of my head is it must deal with something that is, has to do, the term uses imponderable matters. There has to be, I don't want to misstate it actually. And so,
let's do
but
this,
there are
Robert.
three specifically stated requirements that, either your HR professional or your attorney could provide to you verbatim.
We'll include that when we send out the group email with the recording and the
Okay, perfect.
Okay, let me let everybody know that we have 15 minutes left, so we're going to answer this question, give as much as we can, what's left of the presentation, and then we'll be wrapping up. But the one question we have.
Well, let me just say, Evelyn, there are certain cases that have important, and widely applicable requirements that are important. And I'd like to just briefly cover those because I think they're very valuable. And we won't need to cover all the different cases, but I think it's important to cover, at least in passing, the case about wage and hour, meal and rest period recording, and also this attempted ban on mandatory arbitration agreements in California.
Okay.
And so let me just, do some brief coverage if we have a lot of questions to cover on the vaccine mandates. And let me back up a little bit with respect to those Cal-OSHA emergency temporary standards. The types of rules that are in there deal with communications with employees about COVID-related issues, certain things about vaccinations, face coverings and other controls, addressing COVID cases in the workplace, record keeping, and the like. You can look, the Cal-OSHA website has FAQs, which you can consult as to the specifics of those. Now, with respect to those two cases that I mentioned, meal period recording, a case came out that essentially said meal period recording needs to be specific, needs to be precise. And what that means is it needs to be to the minute. Reason being this requirement that it must be at least 30 minutes. And so if you, as an employer, have a system where, let's say it says you just record the fact that you took a meal period, or you just put in the number 30 as your meal period. That previously actually didn't require qualify. But now, if you have a situation where somebody writes in every day the same times and the same exact thing, like 1 to 1:30 meal period, that's going to cause you trouble. And so I think what this case means is going forward, if you still want to use handwritten, you can, but you're going to have the employee put the exact minute that they stopped and the exact minute that they started again. And maybe a much easier way to administer that is through a application, computer application. And there are a lot available. Now, again, then with respect to the arbitration agreements, there was in 2019, there was a assembly bill passed that said arbitration agreements that are made a condition of employment will be void. There was pushback on this. There was a preliminary injunction placed on it, which suspended its enforcement. Then the Ninth Circuit recently, meaning September 15th, I want to say, considered that in full. And they ruled that, and it's a very confusing ruling, but they in part ruled that it is enforceable, and it has to do with FAA preemption, but I'm not going to get into that. The point is, they ruled so far that at least part of that statute is enforceable. But now there's been a what's called an en banc panel review request that's been filed. So that continues to put it on stay, at least for a couple more months. And given what I think there's a collective agreement that the existing Ninth Circuit opinion doesn't make much sense. And so I believe, and a lot of people believe, that it's more likely than not, when considered by a full panel of the Ninth Circuit, they're gonna rule that this assembly bill is preempted by the FAA, and therefore it's not going to apply anymore, because a lot of folks have mandatory arbitration agreements, and the real value of a mandatory arbitration agreement is you can include in there a class action waiver. And that would essentially immunize you from being subject to class action cases. And so I just wanted to at least briefly mention that. And if we have time after the COVID questions, I think we should talk about the issues regarding personal liability of managers, officers, directors, and owners. And
Wait, can I
also,
ask a question, Robert, so in the meantime, until it's finalized with regards to the mandatory arbitration agreements, should employers continue to have them as part of either their handbook or independent policies?
yeah, and that is the most frequently asked question that has arisen out of this uncertainty. What I can tell you is that if it becomes law, it is not retroactive. However, the law has a provision in it that states starting January 1st, 2020, this will, there will be a ban on mandatory arbitration agreements. And so it's a little unclear as to, okay, what's the deal with mandatory arbitration agreements from January 1, 2020 to the time that the statute gets enacted? There's not a definitive answer on this, but I think that if it goes into effect, I don't think you could do an end run around it being not retroactive by having a term in it that states January 1, 2020, because really that date was based on when it was supposed to be enacted. What I can say for certain is, although, without exception or possible exception, all mandatory arbitration agreements before January 2020 are fine. The only question is with respect to that gap in time. But because of what I just said, and you know what, that's a really complicated answer.
I'm like, I haven't heard an answer.
Remind me what the question is. Should they continue?
Should we continue? In my business,
there isn't an answer about, I can't say yes, no, can't say that. And for me to explain what an employer needs to consider in making the decision as to whether they choose yes or no is a complicated, very complicated question and analysis that, happy to answer offline, but I don't think it's something that we can cover in 8 minutes.
So basically, there's no way to say what is a best practice at this point.
Well, if best practice, if we're talking about best practice,
to continue or not to continue,
because of what I said, it's an employer can continue to have mandatory arbitration agreements, and more likely than not, they will still be enforceable even if the law is eventually enacted. But I can't say that for certain. There is a certain level of risk.
Okay, thank you. Thank you so much. We do have a question. On meal times, we require employees to take what's legally allowed, but some employees clock in and out with less what's allowed. Do we need something to prove that that's their choice?
Got it. That is the attestation. And, I'm happy to, if anybody wants an attestation to use, contact me, and, I'll give you that, the attestation that I give to my clients. And that is what they're saying is one of those things that is covered in the attestation. And essentially the wording is to the effect of, if there is an instance in my timekeeping for this pay period wherein I took a meal period or the punches are less than 30 minutes, that is because I chose to take less. Because remember, all an employer's duty is to provide meal periods, provide the opportunity. An employee can choose not to take them at all. They can choose to take a shorter one.
Right.
And if you establish that it was their choice, then there's not going to be a violation.
Right.
And so that's just one of many, or let's just say there's a missed punch, that's covered in the attestation, that if there's if somehow there's a I don't remember exactly what I have, but essentially it covers when there's a punch that is not accurate, or there's a punch where there's a hand, some kind of change entered after the fact. It covers for that. So I hope that answers the question.
I think it does. And then we have another one. For purposes, which I believe this is a yes, but I just want to verify. For purposes of recording meal taken by an employee, can we use timekeeping application software that has break meal down to the minute/seconds? We currently use a meal break card and hand out to every employee. It only has them checking the days they took the meal. It appears that this is not sufficient to meet the requirement. Yes, absolutely.
And yes, as to it's not sufficient, and yes, have it recorded. If you have an application already, then you can easily implement punches for meal periods.
Okay.
And let's just talk about that. If you have a web application or a computer application, I know that at least some you can build into the system the attestation.
Right.
You don't necessarily have to do it in paper or separately by email or whatever. So keep that in mind.
Okay, and then we have two more. Can they expect to take the time later or say they didn't take it then, so I will leave early?
Excellent. Good question. And yes, that is covered in the attestation. If basically says, if I took if my punches were after 5 hours, that means I chose to do it after 5 hours. Okay.
And then it says, but even if they choose to take a meal break less than 30 minutes, or they don't take a meal break before the 6 hours, they are still supposed to be paid for that, correct?
No. If they're choosing to, and you can, the question is, can you prove it? And is the attestation enough to prove it? But the answer to the specific question is, if they choose to do it, then you've provided it and they chose otherwise. So there's not a violation, so you don't have, but if the question is, do you have to pay them for the time that they worked because they chose not to take it? The answer is yes. What you don't have to pay them is the 1 hour premium pay.
Right, so you just pay them, if they're supposed to take a 30-minute break and they chose to work through it, but you provided that opportunity to take it, then you pay them the 30s, not the penalty.
That's correct.
Okay. Okay, and we are down to 3 minutes. Do you have anything else that we had to?
Oh, sure. Joint employment. What establishes joint employment? Main factor is control over wages, hours, or working conditions, directly or indirectly. There's also these vague terms of suffer or permit to work or engage. Really, the inquiry is over control. And so if you've got workers who, are provided by someone else, or somehow there's some, conceptual anyway, separation, you need to look at the control to determine whether you may be found to be a joint employer of that worker. It's a fact-specific inquiry, so it's difficult to, really predict in advance, but you need to do your best and maybe be over-inclusive in your assessment of what makes this, whether this person is a joint employer. And then the other ones are more involved discussions. There's a case that came out that said wage and hour laws in California applies to employees whose employment is based in California. So if you've got people that are working out in other areas, but you meet the qualifications for what this case says about being based in California, then California wage and hour laws is going to apply to them. However, there's another standard that says the laws of the state where the work is performed is the law that applies. So you have a conflict that's unresolved, but we're at the end now, so.
Well, does that conclude the presentation for today? I think so. Because my head hurts too much to hear anymore. I hope, I wonder how many future entrepreneurs would reverse course and decide not to open a business if they attended one of these webinars first. So let's make sure that no future entrepreneurs ever attend one of these webinars. But you guys provided great value. Once again, I just can't believe that I actually learn new things every time that I attend one of these. And at the hourly rate you both charge, huge value for everybody in attendance. And my hat's off for everybody in attendance. We typically find as risk managers that the best way to lower your cost of insurance, lower your risk profile, is by arming yourself with education. And I hope everybody learned something today. Up on the screen again is the limited time offer. I think it's for 72 hours. Anybody that takes advantage of one of these will get that discounted pricing or those free offers. Evelyn, did you want to talk about any of those, or let it serve for itself?
Well, they do speak for themselves, but certainly, we would love the opportunity to help out, any of the attendees. These are a great value, and they're very helpful in assessing the needs that any of the attendees might have. And we would be very glad to, first of all, get a relationship with all of you and see what other areas we might be able to help and support all of you with.
I'm reminded that trying to Google answers is just not a sufficient way of running a business in this highly technical and clear as mud legal landscape we find ourselves in continually. So we recommend everybody reach out to Robert or Evelyn with continued questions or needs. And thank you for your attendance. Again, you will be getting a copy of this presentation, or as Carolyn mentioned, it is going to be up on our YouTube channel. And you can reach out. You'll have Robert's contact information provided as well, so you can reach out directly to him for that attestation somebody asked about. And again, please respond to the survey when you get it. It's brief, it's 4 questions, and it will help us to better curate future information for you. Thank you very much, Robert and Evelyn and everybody in attendance. I hope you all have a great day and take care.
Thank you.
Thank you, everyone.